The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And when you're ready, call the case.
Morning, Your Honors. The matter before the court this morning is the case entitled Alexandra Veljovic versus TD Bank North America et al., case number 24 AP 352. Representing the appellant, Alexandra Veljovic, is Robert Kaplan. Representing the appellee, TD Bank North America et al., is Michael Zullo. Seated at counsel table with Attorney Zullo, representing the appellee Zlata Kavka, is Susan Flynn.
Thanks very much. Good morning, counsel. We'll start with appellant, of course. Come on up to the podium if you would. And before you start, introduce yourself and your client and then go ahead.
Good morning. May it please the court, counsel. I'm Robert Kaplan, here on behalf of appellant Alexandra Veljovic. We're here today with the issue of the economic loss rule and its application to specifically notaries, but in more generally, the liability that service providers have to third parties arising out of the negligent performance of their professional responsibilities. This court has really already addressed this issue in the Sutton case, which involved fraud with the JPEAK project. In that case, the court, looking back to its decisions in EWBS, Springfield Hydroelectric, and all the way back to Long Trail, reviewed the history of the economic loss rule as applied in this state and determined that a service provider could be responsible for the economic losses of third parties through their active negligence. Now, I think it's somewhat significant in this case that we're here on a 12B6 motion dismissal. So I want to just point out at the outset that we don't have the benefit of discovery to really understand fully what exactly happened with this notary transaction. The trial court adopted the reasoning that that really doesn't matter because a notary can't be responsible to a third party. I would suggest to this court that that's not only inconsistent with the law, as this court has adopted in Vermont some of the limitations on the traditional economic loss rule, but it's also terrible policy. Notaries act as the authenticator app for transactions. The role that they fill is very limited. The requirements of the job are minimal. The importance of the work is tremendous. And looking back traditionally at the rationale for the economic loss rule, it really was courts trying to price out of the market unconsidered liabilities. The economic loss rule really starts with the Winterbottom versus Wright case, which was an English common law case involving a repaired wagon wheel that broke. And in that case, the issue dealt with bodily injury and to a person not party to the contract. Under English common law, it was determined that privity was a bar because that person wasn't part of the transaction. The injury to that person wasn't priced into the transaction. And that was the original rationale, which is the ancestor of the issue that we're dealing with here today.
You know, if I could just interrupt you about Sutton, it is a decision that recognizes the special relationship exception to the economic loss rule. But didn't they allege facts in that case that were very much different than what you proposed to allege through the proposed amended complaint that you filed with the court, trial court? Very much different from those facts. As I understand, Sutton had talked about personal solicitation, personal contact, in effect, between the party and the other entity that was claimed to have entered into a special relationship. Isn't that very different than what you have proposed to claim in your, the putative amended complaint that you put forward?
Well, I acknowledge there's a difference in degree. In this particular case, we're talking about a notary who's employed by a bank as a service. And banks use that service to appeal to customers as an incentive to solicit business. So the provision of that service here is of a similar nature. Now, Sutton, I understand, was a much different sort of degree and more direct involvement, which was alleged in that case. Here, we don't actually know specifically what happened because we haven't had the benefit of discovery, and it would be inconsistent with Rule 11 to allege facts that simply are not known that might seem more extreme just for purposes of passing the threshold of a 12v6 motion.
So is your position that being a customer of the bank creates a special relationship?
Well, certainly we do think that is. It wasn't pled in the original complaint because at the time of drafting of that complaint, this issue wasn't contemplated. After it arose, there was a motion to amend the complaint to add that as a factor. And I do think the fact that Ms. Veljovic was a customer of this bank is significant in terms of assessing the relationship between the parties. If you look at the economic loss rule overall, the idea is that parties to a transaction have the capacity to price in whatever risk allocation that they choose to. So here we have a bank and its own customer, and somehow in that relationship, certainly the argument could be made that the risk allocation for notary services is priced into that relationship.
But it wasn't the customer that was asking for the document to be notarized.
We don't know who that person was. That person could have been a customer also.
Right. But the customer that you're relying on to create the special relationship is not the person who asked to have the document notarized.
That's correct. That's correct. This is the purported customer. So for the bank's point of view, if they're operating in good faith, then they would have believed that they were notarizing a document for their customer because the person was in fact a customer of the bank.
Why didn't you file a motion to amend your complaint when you received the motion to dismiss, as opposed to waiting until the case was dismissed?
Not everything that we do is perfect. And in a more perfect world, we might have done it that way. But in fact, in looking at the issues that were raised and looking at the case law, it really didn't seem that specific issue was essential for the trial court to reach what we felt was the right conclusion, which is to say that, notaries are not a special class of service provider who effectively are completely insulated from liability. I mean, the statute says specifically, this is what notaries are to do. It sets the standard. It's a very minimal bar to get over. And so it didn't, at that time, seem necessary to include that one specific fact of relationship.
So, Mr. Kaplan, using the economic loss rule, wouldn't your client have a remedy against her ex-husband for what he did in orchestrating this, getting the document signed?
Well, certainly he is another potential person who could be a responsible party in this case. In electing her remedies, she has chosen to make claims against the negligent party, in this case, the notary and the notary's employer, the bank. It could well be that there were claims that could have or could have been made against her ex-husband. Now, the extent to which those might have value at the time certainly could have been debatable.
Mr. Kaplan, is it necessary to have privity to show liability?
No, I don't think so. So there are New York cases that I think there are two significant theories in New York. One is there is a sort of privity equivalent theory that the courts have applied, where there's a three-factor test where they said, oh, well, these factors exist, then we're going to say it is functional privity. And then there are also the cases which I think are in closer alignment, which have to do with trade certifications. When a third party is certifying goods to be used within a trade, knowing that other parties are going to rely on the certification as to the quality or quantity or whatever of the goods, sort of like a bill of lading, that liability is assumed with respect to the certification, whatever that party is authenticating. In this case, the notary's job is identity. Like the service is identification. That is the good in the transaction.
Thank you.
And so I would urge the court to recognize what we believe the law already is, which is to say that the privity standard, which was used originally to exclude bodily injury claims in products liability, which was then functionally abandoned over time, really is being subject to the same process with respect to economic loss. And where the economic loss is causally related to the negligence of the service provider, much like a professional service provider to their contracted customer, that where that causal relationship exists, liability should follow. And the argument against this has always been, the specter of unfettered risks, of unknown risk anytime a professional service provider is providing a service and there's potential liability to third parties. But it's really no different than with products liability, where manufacturers may not know who it is or who might be injured, but they're able to price that risk into the products through better design and insured.
Can you explain to me the contracted customer theory that you just talked about?
Sure. So there's already this recognized idea that professional service providers can be responsible in negligence, like a lawyer to their client.
Right, there's a professional relationship
Yes.
between those two.
Yes, but basically it's contract plus. It's a contract obligations plus a special duty, which is imposed by law because of the nature of the relationship. What we have here is essentially that one, but maybe one step further out, because in this case, where the primary function of a lawyer, for instance, is to do a professional service, which is going to be aimed most directly at that person standing on the other side of the desk. With the notary, it's different because the service is authentication. The notary knows that the reason for doing this is for some other third person to rely.
But does the
on this.
notary have a fiduciary obligation to a person that they're signing? A
I'm
lawyer
sorry,
does.
I couldn't hear.
Does a notary have a fiduciary responsibility to the person that they're signing?
Well, they certainly have the professional standard relationship. I don't know that I would say that it's a fiduciary duty. I mean, the notary's job is to look at the list of required identification of proof of identification and then do their job.
The relationship between your client and the bank, though, is a banking issue. And doesn't it matter that your client didn't know anything about this and didn't ask that this be done by the bank? How can there be a special relationship when your client didn't even know this was going on?
Well, the special relationship really relates to the expansion of liability, and the special relationship extends to the people who are causally harmed by the negligence. So for instance, with a notary, the notary knowing that the whole point of the service is to authenticate the person's identity, essentially is in a special relationship with whoever is, is harmed.
So if that document is wrongfully obtained, notarized when it shouldn't have been, and then the person takes it and uses it for his own purposes or her own purposes at 100 different locations, all 100 locations have a claim back against the notary?
Yeah, but it's an expansion on, it's not to say that all 100 of those individuals entered into a special relationship. It's the expansion or the extension really of what the court has already recognized in Sutton, as to say when there's a causal relationship between the conduct of a service provider to a third party, and there's an awareness that third parties are going to be relying on the work, that liability exists. I see that my time has
Thank you.
expired.
Thank you. Your time has expired. I think your phone is up there too.
Counsel?
Who's that?
That's my phone. I work here, so I'm using that as a listening.
Oh, that's your phone. Okay. Well, who's arguing?
I would be first, Your Honor, and then Attorney Zubo.
You're splitting your time and you've talked to the bailiff about all that, I'm sure. Yeah, okay. Please come on up and for the record, introduce yourself and your client and then proceed.
Thank you, Your Honor. May it please the court. My name is Susan Flynn. I represent Zlata Kafka in this appeal. Fundamental to the economic loss rule is the idea that there's no general duty of care to protect the public from financial harm, absent very limited exceptions. There's no reason presented by this case that those exceptions should be expanded. We've been talking about, for obvious reasons, the special relationship exception. To Justice Carroll's point, there's no relationship between the plaintiff appellant here and my client or the bank relative to these notary services, the ones that are apparently were fraudulent. Because there's no relationship, it's extremely difficult to argue that there was somehow a special relationship whereby my client was being entrusted with the well-being or the protection, obligation to protect plaintiff appellant in this case. I think it's really important to understand that notaries are not folks that have specialized degrees in that services. Notaries aren't specially trained, unlike our neighbor to the west, notaries in the state of Vermont, that's New York State, notaries in the state of Vermont are not even required to take a test in order to provide the services. They're very basic services. They're services about identification and verification. They're not specialized. They're in no way communicating to the user of those services, come to me, I can take care of you in this challenging situation, as would be the case, say, with an engineer or an attorney or a doctor and an accountant. We regulate in the state of Vermont all sorts of service providers who are not exposing themselves to what is effectively some kind of malpractice liability. We regulate dairy technicians, educators, crop adjusters, chimney sweeps, dental therapists, foresters, electrologists, notary publics, nursing home administrators. All of those folks provide services, and the professional nature of those services are protected through the regulatory scheme that we have in place. In fact, a regulatory scheme that plaintiff appellant here utilized. In other words, she brought a professional complaint against Ms. Kafka, claiming that she somehow acted negligently relative to this fraudulent signature procured by her cad of an ex-husband. She brought that complaint. The complaint was investigated and no wrongdoing was found. For the obvious reason, I think it bears note that my client's signature was likely forged just in the manner that plaintiff appellant's signature was forged. Now, that is
We
not
don't- we don't-
particularly
Ms.
critical
Flynn,
to these
I don't mean
arguments.
to interrupt, but we don't really know the circumstances involving the signing because no discovery was done. So we don't really know who appeared, what was said, how it was done. That's all kind of an unknown in this case, correct?
It is, Your Honor. It is. And I frankly make that point because it is of critical importance to my client, but I do concede that legally, for purposes of our analysis, it has very limited usefulness.
If there's liability or potential liability for your client in this situation, isn't the upshot of that going to be that notaries are going to be difficult to find?
Very difficult to find because they're going to have to procure malpractice insurance, as are dairy technicians or educated. If we carve out an exception for notaries, to your point, Justice Eaton, yes, they're going to be difficult to find. I think it would be problematic to provide those services, as many of us do, free of charge, right? Without having some protection of some kind of malpractice insurance, which would make the service, everybody who's providing it free of charge, it would not be provided any longer. This is not the kind of scheme. It could be that we require testing of notaries. It could be that we require some kind of education of notaries, or that we require that they have degrees in that field, in which case it may be appropriate. If the legislature saw fit to do that, it may be appropriate for them to bear the kind of exposure that a doctor or an accountant or an engineer would under these circumstances. But we don't do that. Their services are very limited. And certainly it would seem that those services, the effective provision of those services is adequately protected by the regulatory scheme that we already have a place, again, a scheme that plaintiff appellant availed herself of. The idea that somehow you're looking at a license or an identification document without any requirement that you be trained in forgery or signature analysis, or even when a witness is being truthful or untruthful, as might be the case in for some kind of investigators. The idea that somehow you're looking at this identification, saying, is this you? Watching the signature, it's the same. You do that service and you could potentially be responsible for hundreds of thousands of dollars if that signature is somehow wrongfully procured, if you've been misled in the information that you've been provided in order to do your job. That just seems so far beyond what we actually ask of people in positions like notaries. And as I say, all of the other professions that we license, and we seem to feel comfortable we can regulate through the licensing process rather than carving out some a large exception to the economic loss rule.
Did you say that the notaries in Vermont don't need to take any kind of education or classes or anything like that?
They do not, to my knowledge. Yeah, I know in New York State, you have to take a test, as my daughter told me this
But
morning.
not in Vermont.
But not in Vermont. You pay a fee. You pay a fee and you sign your name, and perhaps you may make an assertion that you're truthful or ethical. I can't recall that detail,
Ms.
but
Flynn, I don't want to use up your co-counsel's time, but is there liability for the misleader, the person who misleads?
absolutely. I think that's the obvious problem here is that there was this ex-husband who was willing to do something fraudulent that had significant consequences for, I'm afraid, Ms. Veljovic. I hope I pronounced that properly. And we have no idea. I mean, she may be availing herself of some remedy provided by the Serbian courts as we speak, but it stands to reason that if he in fact did something to defraud her of money in a property settlement to which she was entitled by using this document in a Serbian court, as is being alleged, that there would be a remedy through those courts. I don't know anything about the Serbian legal system, but I find it hard to believe that you could defraud a court and not have an adequate remedy of law to undo that. Yeah. So I think that's exactly where the remedy does lie. And I think in all fairness, there is no need to expand that remedy to include a notary whose services are quite limited, as I mentioned. I will cede my time.
Let's find out how much time is left, please.
6 minutes, 54 seconds.
All right.
Good morning. May it please the court, Michael Zullo for TD Bank. I would like to pick up on a couple of points. We're talking a lot about the special relationship, and I think it's critical to examine what the plaintiff is trying to say here, because there is no relationship between the plaintiff and the notary. And the reason that that is really an important fact and really fatal to the argument that the plaintiff is making is because the notion of expanding the argument to create this exception to the economic loss doctrine finds its roots in the idea of reliance, meaning that a third party is relying on the services being provided by the notary. And in this situation, and the plaintiff admits this in their brief, when they discuss the Media Glow case from New York, which sets out the basis to look beyond the privity for expanding the economic loss doctrine, the plaintiff says that the party that relied on this document is the Serbian court, not the plaintiff. So by her own papers, she's telling the court that even if the court were inclined, and I don't think there's any reason to expand the doctrine, but even if the court were inclined to expand the doctrine, you have to look to the party that relied on the document as the basis for expanding it. And here, plaintiff didn't rely on this service. The plaintiff didn't rely on this document. What the plaintiff is saying is that this document was used in a foreign court to procure the disposition of marital assets. And Justice Eaton, Justice Cohen, I think this goes to your question about remedies. Plaintiff is not without remedies here. In any situation where there's a transaction and the transaction is fundamentally based on a fraudulent document, you can seek to undo that transaction. And that is the remedy. And one of the cases that is cited by the plaintiff, the New Jersey case, Immelhoff, I believe is the name of it, talks about the fact that the bank relied on the notary services in advancing loan funds because the documents that were the loan note were notarized. And because the notarization was improper, the bank was the harmed party. So again, the concept is reliance, and the plaintiff can't allege that she relied on these services. In fact, she's saying, I didn't rely on these services, and the Serbian court relied on these services. So there's no basis to expand this doctrine to cover a situation, whereas here there's absolutely no relationship. All of the other economic loss cases that this court has considered, on a fundamental level, there has been a relationship. And Justice Weber, you opened your questioning with the Sutton case, where there are actual allegations, facts, that a party is making a representation, inducing another party to rely on those representation. And in certain circumstances, there may be a special relationship created. The other issue I would like to address is the notion that the mere existence of a banking relationship here somehow, which is not in the record, but for purposes of the argument, that somehow that relationship itself creates a special relationship. Well, that's not true, because then any relationship would be a special relationship. If the standard is there's a relationship, therefore it's a special relationship, there would be no need to have this special relationship exception.
Mr. Zullo, does a notary have a duty to perform his or her responsibilities appropriately?
The notary has a professional duty to perform her responsibilities, his or her responsibility, but that duty and the duty extends to the person relying on the services. And so in this situation, the person who is purportedly relying on the services, according to the plaintiff, is the ex-husband and the Serbian court. And I think that brings us to another very important situation, because we're talking about the threshold inquiry of, is there a duty? But that doesn't end the inquiry. The next step is, well, if there is a duty, and I don't believe there is, and I think the case law is clear that there's no duty, but if there is a duty, Was there a breach of the duty? And then did it proximately cause the harm? And what the plaintiff has not been able to explain, and what the record doesn't support, is a direct causation between the alleged breach of the duty here and the ultimate harm. Basically, what the plaintiff's saying is a notary notarized a document. That document was then presented to get another document. That document was then domesticated in a foreign territory to procure legal services of a lawyer who then appeared in a foreign legal proceeding on behalf of the plaintiff and made presumably agreements to a proposed marital distribution of assets presented to a Serbian court that ultimately was entered by the Serbian court. That's 5 steps along the chain from the document. And there's no allegation in the complaint here, and I think this is critical, that when the notary notarized and I will not try to pronounce it, the pomosi, or the equivalent of the Serbian
Better job than I did.
the
son.
Serbian equivalent of the power of attorney. There's no allegation that the notary knew what that document was being used for.
So, Mr. Zullo, does that then indicate that perhaps because the trial court denied the appellant's motion to amend the complaint, that some of that could have been developed, and was that an abuse of discretion by the court?
So it's a very good question. I think the answer is no. And I think the reason the answer is no is, first of all, as a pure factual matter, the threshold issue, there's no relationship. So there's no need to even get into the causal chain, because there's no relationship. If there's no relationship, there can't be a special relationship. The second component of that, though, I think, is procedurally, once the judgment was entered, leave to amend is not to be freely given. There needed to be a basis to overturn or open the judgment. And the lower court determined that and the last thing I would say is, again, with respect to the single allegation that the plaintiff was a customer of the bank, that doesn't change the analysis. There's no facts here alleged to create a special relationship or to even show that that should be imputed to the employer.
Okay.
Thank you.
Thank you very much. Your time has expired. Does the appellant have any time?
The appellant has no time remaining.
Please call the conclusion of the hearing.
The next